go ahead and get started here. So good morning, everybody. Thank you so much for taking the time to join us. We're going to get started as we have a lot to go over today, and we want to make sure we will have time to address any questions. Colony West is pleased to bring you today's webinar hosted by Outlook HR featuring Huddock Employment Law Group. Today's webinar is being recorded, and a copy of the recording will be forwarded to everyone who registered for the event, along with a copy of the presentation. Be on the lookout for that link in the next day or so. If you have questions throughout the session, please use the Q&A box. We do our best to address all questions during and at the end of the presentation. At the end of the webinar, we will ask you to participate in a 4-question survey, as your feedback helps us improve and bring you the information you need. So I am Evelyn Blanco of Outlook HR. I have over 20 years experience in human resources management, and I'm certified by SHRM. I am bilingual in Spanish and have extensive experience with practical implementation and reasonable implementation while keeping you in compliance. I have heard about just about everything. Also, we have Robert Huddock of Huddock Employment Group joining us. Robert has over a 20-year law career with 15 years specifically representing employers in employment law matters. Robert also provides employers with employment law education and solutions to protect themselves from claims and navigating workplace challenges. Thanks for joining us today, Robert.
Thanks, Evelyn. Thanks, Evelyn. Good morning to everyone. Happy to be here, and thanks for attending. With remote work, it's no secret that the pandemic changed a lot of things in terms of where work is performed. That's true at least in the near short term, but very likely it has changed the culture. And so absolutely, I think everyone that has a situation like an office situation, or as opposed to, say, a manufacturing situation where everyone needs to be there to perform the work, really needs to think about their remote work situation and how to handle that. The key consideration with respect to thinking about remote work is, what is the workplace for that remote employee? And the concept of workplace involves both the geographical location where the work is performed and also the setting in which it's performed. And let me talk a little bit about that. And the reason why these are important, because any one of any one factor in terms of setting or location can have implications for both what the requirements are and how you may want to approach your remote work situation. So let's talk about possible settings. That could be, for example, the most common example would be the employee's home, but it also, depending upon what you allow your employees to do or what the specific situation of an employee might be, it could also involve performing work at a relatives or friend's home, maybe a off-site shared office space, could be a public space, maybe coffee shop, library, outdoors, and it may be any instance where people are traveling, plane, car, train, what have you.
Sounds like a movie.
There's also an issue of possible geographic locations, and this definitely has implications to the extent that it is either out of the city in which you work and where you consider municipal specific laws, or out of state. And some examples of that would be, for example, all work performed within the same state and city, work sometimes performed in different cities, states, or countries. And so I want to just go through I want to apply this and say, okay, here's what specific examples you might have or you may have in the future. And so we talked about a single, well, let's just assume it's a single location and setting. Somebody has a home office in Santa Monica. Here, California applies, but local Santa Monica law regarding minimum wage and sick time also applies. You may have a single geographic location, but various settings. For example, someone might perform all their work within a residence, or they might have the other settings in which they might perform it all within Santa Monica. That's the more simple one.
Robert, I want to clarify something you just said so I understand correctly.
Yes.
So if I work for a company based in Orange County, but I live in Los Angeles, then the minimum wage has to be honored for Los Angeles for my work, as well as the sick leave law and any other laws that pertain to LA. Is that correct?
That is correct. And the rule there is the employer needs to follow the requirements of the rules that are more generous to the employee.
Got it.
There's also those complications of, the municipal laws apply to work performed within that municipality, but doesn't apply to work performed elsewhere. And that's the kind of thing that we're getting into when we talk about the location. Geographic location is more important, and how simple the remote work situation is. If you've got a employee that's could be or is sometimes in Santa Monica, sometimes in LA proper, sometimes in San Francisco, then you're going to need to look at all those situations if you want to make sure that you're complying with everything that potentially applies.
Okay. Thank you.
And
nice to say thank you for answering.
Okay. Now, you could have, and this is what we just discussed, you could have various locations within Santa Monica, but different settings. For example, the home office, the coffee shop, outdoors, what have you. And then increasing in complexity, you could have various geographic locations and setting. Home in Santa Monica, parents' house in Arizona, sister's house in San Diego, the beach in Venice, a hotel in Bali. All of those things could potentially apply. And one of the things to pay attention to is, do you know where your employee is performing remote work? And we'll get to that issue a little further down. So other questions that arise with respect to this situation. What laws and regulations apply to each of my individual employees and each of his or her individual circumstances? Do I have safe workplace obligations for my remote employees? Do I need to do anything different in connection with workers' compensation insurance? Is the company liable if an employee who works in a home office has a visitor who is injured in the employee's home? Do I need general liability insurance for all remote workers' homes? How can I control my employees' work or otherwise handle the realities associated with work performed outside of a common workplace? And are there strategies for handling all these complex issues? The good answer is yes, there are strategies, and that's what we're here to talk about. We're here to both identify, we want to stimulate your thinking by giving you these possible scenarios so that you can start thinking about when you need to pay attention to things and how you approach it.
Yeah.
So, now, the goal here, the goal with any remote work consideration is to both manage employees' expectations, minimize possible claims, and know what, like I say, what jurisdictions or what rules may apply, how to figure that out, those types of things. So let's talk about some possible issues that you may need to consider, which involve questions about what is an employer who has remote work employees potentially liable for? What might they be held legally responsible for? And the first issue that we'll cover is discrimination. And remember that any claim requires that there be an adverse employment action. That's what the law says. The adverse employment action is most typically termination, but it can be many things. An adverse employment action is any action that materially and adversely affects the terms, conditions, or privileges of employment. And so what can that be? It could be, if you look at remote work as a privilege, it could be that you provided a certain group the privilege of working remotely and not a certain group or individuals. Theoretically, there could be a claim of discrimination where remote work could be a potential detriment. For example, if you have people who are working in the office getting more opportunities, chances for advancement, and so forth, and better treatment, then you could have a discrimination claim based on that. However, remember that not all discrimination is illegal discrimination. It must be based on a protected category, and that would be your age, race, nationality, and so forth. Another claim that could definitely arise would be a harassment claim. How does that work with remote work? Well, employees that are not in the office and at home may have a different mentality, and they may consciously or unconsciously not adhere to the same standards as if they were in the workplace. They're at home, they're casual, and they just don't think, like I say, it could be unconsciously. They feel more informal. There could also be, and this one's fairly obvious, video conferences. You know, is there something that's happening in a video conference that could be considered harassment based on a protected category? Yes, there is. Could be a picture on the wall, could be an item on the desk. And then you have the classic situation of, you know, the no pants. And that's going to be obvious. And if they stand up, that's obviously something that's going to happen. Matter of fact, I know a specific example where a woman was doing a video conference, and her husband, without knowing she's in a video conference, walks by the screen naked.
Oh my goodness.
And so obviously that's going to be something that impacts any analysis. Now, again, on the however side, remember that hostile work environment, sexual harassment, the conditions must be severe or pervasive.
Right.
So husband walks by naked, maybe severe. If there's a picture in the back and they're having frequent video meetings, maybe pervasive. So you got to keep your eye out for that. And there's also the related claim under the FEHA of retaliation. And that could take any number of forms. It could be that the employee notifies or complains to the employer about something they reasonably believe is illegal. For example, the employer is not properly applying law to remote work. Another employee is behaving inappropriately. Another employee may be treated more favorably. If then there is a separate adverse employment action that's, for example, within a week of that complaint, then you could be facing a retaliation claim. But again, there must be an adverse employment action, and that requires the employee to show a causal connection between the employee's complaint and the adverse employment action. Another one that can arise is disability accommodations. And here, the same requirements and rules that apply to employees in situations in the common workplace also apply, but maybe slightly differently in a home office setting, for example. And also note, another interesting thing to note with respect to disability accommodations, in certain instances, remote work itself can be an accommodation. And that's something to always look out for. Next issue, which if you have employees performing work in other jurisdictions. So in California, employers are required to reimburse employees for all necessary expenditures or losses incurred by the employee in the course and scope of work. There are issues with respect to in California only employees, and that is, what are necessary expenditures in a remote work situation? Could be slightly different. Now, one important thing is, does an employer need to provide equipment or services when the situation is remote? For example, does the employer need to provide, or should they provide, a work computer, a mobile phone? Now, with respect to services, there could be, for example, internet service, cell phone service. What about electricity? Maybe so. And here are some of the standards. Or let's talk about one consideration in connection with providing the equipment to use for work purposes. The advantage of this is it avoids certain reimbursement complications, like the questions that I was just asking. And then it also can avoid possible complications with IT security for your company, or if you choose to monitor that employee's emails or productivity. And so go to the other situation. If a remote worker uses something for both work and personal use, California law is that the employer needs to determine and pay a reasonable portion of the equipment or service use that is attributable to business-related work. Again, mobile phone service, employer needs to pay a certain percentage of that. Internet access, possibly and most likely. And in that situation, there's no hard line rule as to what percentage should be used, how you determine that appropriate percentage. It could be the best rule of thumb, maybe 50%, and I think I'd do at least 50% in any situation. If you have clear evidence that its business use is extensive, then you'd have to provide more. And this really isn't something that you want to mess around with, basically, because it involves a relatively amount of money. It should be. And why take chances in that situation?
Robert, let me ask you, so for example, with electricity, everybody needs that to run their computers, which so it would be 50% of their electric bill. That seems a bit much.
Right. So as I was saying before, electricity is a big question mark.
Oh.
But what I believe the analysis would be is that it wouldn't be something that they need to reimburse for, because how can it be segregated?
Right. That's what I was thinking.
And if it can, it would be far too complex of an analysis for the amount at stake. That's
All
my
right,
hope.
but okay, thank you for clarifying. And then, but generally speaking, if I understood you correctly, then we're talking about 50% of internet and 50% of cell phone. And I have a question on the cell phone. If a company provides a different, so if you're not requiring your employees to use their cell phone, but they choose to, then you're no longer required to reimburse them for that. Is that correct?
Well, that depends on what the employer knew or should have known. And we're going to get further into that concept because
Okay,
there is a clear rule regarding what an employer is responsible for in different situations where they don't have an opportunity, such as in a common workplace, to be looking over them.
got it. Thank
And
you.
that applies in various situations in connection with remote work. But I'll note right here that it doesn't apply to time worked. An employer has to pay for time worked, whether it was authorized or not, whether it knew or
Right.
didn't know. Well, let me qualify that.
Okay.
In certain times, or I should say, the knew or should have known does apply to, for example, overtime work. And we'll talk about that more. We'll get into that a little bit more. But
Okay.
to reiterate, a lot of these concepts applying, what applies to them is this rule of knew or should have known. Now, if you have employees in other states, whether temporarily or permanently, then keep in mind that various states have different reimbursement rules, and many states don't even require reimbursement by the employer. So that's an example of where work in another state can certainly benefit an employer, and typically would, as long as they're not doing any work in California, because anywhere other in California is going to be beneficial to the employer, as we know.
Yeah, correct. Thank you.
And so let's talk about some wage and hour issues. Let's say work schedules or availability. Employers can have requirements for when the employee can and cannot do their remote work. They can also set standards for availability in terms of the hours in which you need to be available or the time frame in which you respond to any communications, whether that's from a client, customer, or internally within the company. Timekeeping. The employer should have very specific requirements, or they should have very specific requirements with respect to how somebody does their timekeeping, what's specifically allowed, what isn't. And the best option for remote workers is any one of the various timekeeping applications that are available to employers. They have things such as, okay, how much time, were they on the computer? What location were they at when they performed the work? However, that has a double-edged sword, of course, when you look at knew or should have known. If you have a rule that the employee can only perform work at their home office in such and such city, if you've got data showing where they actually did, then do you have that defense? But the important part is you have data that has much less of an opportunity to be fudged or misrepresented. And that's going to be something that helps. I imagine you can have certain features of any of these remote timekeeping applications. And
So I want to ask, I'm sorry,
go
Robert.
ahead.
just one question. I just want to clarify. So for your non-exempt people, you can, I suppose for exempt as well, but you can have a policy or requirement that they do their work at a specific location so that they're not
Yes.
running around town, so to speak.
Yes, and that has multiple advantages,
Okay.
which we're specifically going to talk about.
Okay, perfect. Thank you.
Now, let's talk about breaks. The employer must provide, and this is in California, must provide them just as if they were in a common workspace. And this again is where a timekeeping application can assist, because having data that they actually punched out and actually punched in and not being able to write it down for something else is going to help you both in terms of compliance and any defense if they were to bring a claim later. Now, another thing I want to mention is a strategy that is applicable to all situations, whether it's in the office or remote work, and maybe it's particularly helpful in remote work, is something I've discussed in previous webinars, and that is what I call a time period certification. And basically, I'll just describe it generally. It's a document that states the employee certifies, I've taken all breaks. I didn't work any overtime. If I didn't take breaks, it was because I chose not to. And that means you still provided it. They chose not to.
Right.
And that's always helpful. And we can talk about that more if we have time or if people want to know more about it. Then overtime. Again, with other things, when working outside the office, there's much more opportunity for overtime abuse. And again, employers must pay for all time worked, whether it's authorized or not. You can have standards within your policies that, again, both minimize that opportunity and also serves as a defense. For example, all remote work is to be performed between the hours of 9 and 5 p.m. You are not allowed to work, anything outside of 5 or as you see fit or as it fits, as you want to.
Right.
That's one possibility. Because look, anybody could say, oh, I have 10 minutes, I'll pick up the computer, and do work at 11 o'clock at night.
Right. And so hypothetically, if an employee were to, start to increase their overtime, the half hour here, 20 minutes there, and you have an explicit policy that says all overtime must be approved, then you could treat that as a performance issue and discipline accordingly, correct?
Exactly. And that's exactly what you do if it starts to become a problem.
Mm-hmm.
And here's again where the knew or should have known can come into play. If you have a policy that, and this applies to any policy about must be authorized. Mm-hmm. If someone doesn't get that authorization, you'll have to pay for that time. But
of course,
you wouldn't have to pay. Well, let me qualify that.
Okay.
You would need to pay for time that you knew or should have known about.
Right.
If you don't know or should have known, you're not going to have to. Okay. And that's why you have these policies. That's why you have, this principle of must be authorized. That's going to be what you use in defense of an overtime claim or working off the clock or anything like that. And then finally, let's talk, or in this, or with wage and hour, let's finally talk about payment methods. That's going to be direct deposit. In California, an employer can't require that an employee does direct deposit. So if someone doesn't specifically authorize direct deposit, you're going to have to come up with a sufficient alternative means of paying that employee. Let's go quickly through a couple more so we can keep track of the time. Workplace safety, workers' compensation. Employers have some level of requirement to provide a generally safe remote work environment, at least when the employee performs their work at a home office. And we'll talk later about how you can meet those obligations. And then just like workers' comp, in the former world, and employees can suffer a workers' comp injury anywhere. It doesn't have to be within the office, but it does have to be work related. So you have to keep that in mind. And so, for example, consult with your brokers or carriers about what coverage, what scope of coverage does it cover? Does it cover, are there terms in the policy that cover remote work performed in somebody's home in some other state or whatever the situation is? Then there's the similar question of general liability. And this involves liability to third parties because any injury that the worker may suffer is in the workers' comp field. And there's actually a case that, or let me describe the situation. If someone is visiting your home or your home office where that employee is working and that third party is injured there, is the employer liable for the injury to the third party? There's actually a California case that involved this. And what the situation was, very unfortunate situation. The employee had other employees come to a meeting at her home. And she had a son that had post-traumatic stress from combat experience. And just to state it straight, he went into his room, got a gun, and opened fire on the group meeting. And obviously, some people were killed, some people were injured. And what the court looked at to determine if the employer was liable for those injuries are things like foreseeability, whether the employer took actions regarding the home that could be considered associated with business ownership, whether the employer otherwise exercised control over the home workplace, and public policy considerations. In that case, they found for several reasons that the employer was not responsible, but they didn't limit their opinion to third-party criminal conduct. Any other situation would have an individual analysis. How about mandated notices? The notices you put up in the lunchroom. You've got to determine a way to provide those to remote workers, whether that's providing electronic copies over the computer, which is probably sufficient, or it could be paper copies that you instruct them to post in their house. How about supervision productivity? For example, tracking employees' work, data review. And again, we talked about how in a situation where the employee is using a personal computer for both, how do you segregate between business use that you're allowed to look at and personal use that you're not? Then IT security, you got to think about, okay, are we putting the proper security protocols with respect to handling, such as security applications on a computer? And again, that's where providing equipment, it becomes much easier, much simpler. I-9 compliance. An employer cannot rely on copies. They've got to put their eyes on the original documents. How do you deal with that? There are services where, let's say, someone's in another state where that service can look at the originals, and that can be found to be sufficient. The other thing is E-Verify, which you don't provide them with documents. E-Verify can find documents that are available in government databases. Such as driver's license, Social Security, and so forth. With respect to geographic pay differentials, I'll simply say that those have been around for a long time. So an employer is allowed to have geographic pay differentials for someone either they hire that works in another state, resides in another state, or someone that was an existing employee moved to another state. It's just a matter of employee relations, basically. And do you want to potentially lose that employee? Because let's keep in mind, the market for employees has expanded exponentially. So they may have a lot more options than they used to, and therefore be more apt to leave a job where the conditions aren't as they would want them to be with remote employment. I'm going to spend not much time, if any, really, here on work outside California. This would be applied to both a situation where the employee works sometime out of California or resides outside of California or performs all their work in some other state or municipal jurisdiction when it's applicable. Again, think workplace, location, geographic location, where the work is performed, because that's the general rule. The laws that apply are where the work was actually performed. And so differences among laws. There's all those issues in the issues that we identified earlier that can be different from state to state or municipality to municipality. Additional issues: unemployment insurance, unemployment contribution, wage statement requirements, family and medical leave, the time that you pay, what pay periods need to be, what paid time off standards are there, and also tax considerations. Now, there is potential existing guidance in other similar situations, but not on post-pandemic remote work specifically. So for example, what existed before are things like outside sales, airlines, truck driving. Now, in those situations, for example, airlines and truck driving, there may be a collective bargaining agreement, which makes things simpler because you're following the collective bargaining agreement. But then there would be a two-step process. Very simply stated, you'd need to determine first whether California laws apply extraterritorial, meaning in certain situations, it may be California law that applies even when the employee performs work outside California. The courts have engaged in a very complex analysis where they look at things such as how much time does the employee spend in each jurisdiction? Where's the company headquarters and what kind of connections do they have to California? Where's the employee's residence? Where did the alleged wrongful conduct occur? And so it depends on the individual circumstances. And then also, if there's not that extraterritorial application, you're going to look at the law of the state or states in which they perform work. And if we have time, I can go back to more detail with respect to that, but maybe none of this applies to people or very few people, so I'll move on. Okay, let's get to the most.
We have a question.
Yes.
Robert, sorry.
No.
What about other countries? We have some employees working remotely in Mexico.
Very good question. Yes, it would be the same as if it is in another state. So you can see how complicated that might get. In the situation where the employee is always in some other country, it's a little bit simpler, but you do have to, if you want to comply and you want to be, tighten things up and be the most safe, you're going to have to become familiar with the laws in that country. It gets more complicated, however, if you don't do anything to address, let's say you don't have any requirements as to where the employee performs work. Well, they're going to go to, like I said before, they're going to go to Bali and for a week, and they're going to perform work there. And then they'll go see their mother in Wyoming. It could get very complicated. We'll get to that when we talk about approaches and strategies. And let's get right into that. Because of the things that I've mentioned, planning and analysis in the front end is very important. Employer needs to evaluate their own individual circumstances, and then based on this, determine the best approach and strategies. This may involve, and then that analysis could result in changes to how employees or an employee performs his or her remote work, an emphasis that certain existing policies existing for the people that perform work in a common workspace equally apply to remote work. But I think it's essential that an employer look at some level of specific remote work policies for that employer. That's going to protect you quite a bit. And along the same lines, what I'm going to talk about a little bit is a remote work agreement. So let's talk about remote, what the benefits are of having a remote work policy.
Robert, I'm sorry. We have a question.
Yes.
Okay. Is an employer responsible if an employee is injured while working remotely from a non-residential place? For example, an employee lives in Los Angeles, but the employee has a home in Mexico. Employer found out after that the employee was vacationing in Mexico while apparently working from home.
The answer to that would be what I was saying before, which is, as we know, let's say you have a truck driver, or let's just say you have an outside salesperson in California and you're in Los Angeles, and they get injured when they're seeing clients in San Francisco. That's going to be workers' comp. Now, without certain controls about where you can perform your work, they go to vacation in Mexico and they're, however they're performing their work while they're in Mexico, whether that's vacation or otherwise, if it's in the course and scope of their work, that's going to be a workers' comp situation. Does that answer the question, you think?
I think so. I think that, for example, I myself was recently out of the country and I did some work. So if I'm working, sitting at a computer on in this other country, and I don't know, my wrist hurt, I think that that's understandable that would be workers' comp. However, if while I'm in the other country not working, I slip out on the beach, then that is not workers' comp. But that depends. Yeah, so that depends basically on how honest the employee is, I would think.
Well, I guess, and also an evaluation of, was it in the course and scope of work, performing their job duties?
Okay,
that's the key consideration.
Yeah. Okay. I think that answered their question. Yes.
Great.
Sorry.
So the benefits of having a set of remote work policies is it can give an employer some level of control where it otherwise does not if they were in an office. Again, going back to knew or should have known, policies can allow employers to take advantage of that rule where it applies, that they're responsible only for what they knew or should have known. And then again, they can use these policies as a defense if there's ever a claim that comes up. Let's go over some subjects that may be covered in a remote or remote work policies. You can define which employees are eligible for remote work. That addresses potential discrimination. And here we go, the work locations allowed, the work schedule allowed. This I see as a very important one because it is really the only way to simplify to a manageable degree this whole thing about, going on vacation here, performing work at 11, getting up in the middle of the night and performing work, performing work for 12 hours one day, 0 hours another day, and those things. And so, you could say all work, all employees are required to work between these hours, and they are expected to be available during all these hours, and they must perform that work in X location, whatever that is. And that avoids, all the administrative complications that may arise otherwise, or opening yourself up to potential liability. Let's talk about, there's rules regarding the physical workplace or workspace. That can serve to, you can have safety rules, and that could potentially serve as an employer meeting its obligation to provide a safe workplace, for example. And it also may serve as a defense with respect to that. Okay, then we talked about this before. Specific video meeting requirements and preclusions, if you will. And also, you could define specific protocol for the meetings. You will have a blank background, just as an example. And then wage and hour. That is about the schedules. It is about protecting against overtime claims that may be more or when there's overtime work, more likely in a remote situation, and so forth. Then again, going back to what we talked about before, defining what equipment is used, how reimbursement is done in their situation, and what they can't use, what they are precluded. You need to, for all business use, you must use your company cell phone, or, it could be a blanket preclusion of using personal cell phone. It could be rules regarding records that need to be kept in order to separate out business use from personal use. These are just some examples. We talked about IT security. That's going to be, for those that have sensitive information, you really need to have some form of security protocol, specifically applicable to remote work. And then again, if there's employee monitoring, best practice is to inform the employees of the monitoring. But again, the point here is you would want to have, if you're going to monitor, that's going to be something that you'd want to include in remote work policies. And with respect to remote work agreements,
Robert, I'm so sorry to interrupt you. One question.
Yeah.
Do any of these, does the size of the employer matter? For example, like CIFRA, that's 5 or more. Does it matter if you have 1 employees or 1,000 or 100 or 50? Is there any?
It can. And the point is that leave laws differ from jurisdiction to jurisdiction.
Right.
For example, California, as long as you have 5 employees anywhere, CAFRA, California Family Rights Act, applies.
Right.
Whereas in a state where the federal law applies, it's going to be that count within a 75-mile radius, 50 within a 75-mile radius. And there are differences between other things with respect to CAFRA and other things with respect to FEMLA.
Right.
And so that's the kind of thing you have to evaluate in terms of counts. Also, with respect to counts generally, there's also that situation where certain municipalities have different rules applying to different counts.
Right.
As you may recall.
Right. But do any of these, do any of these solutions that you're suggesting, or any of the compliance that's required with remote work vary depending on the size of the employer, or no?
No. No, these are policies that would be generally applicable to everyone remote working.
Okay,
no
great.
matter their
Thank you.
situation, no matter where they are. However, well, no, I was going in the wrong direction.
Okay.
Leave it.
All right. So thank you.
So going to remote work agreements, stated very simply, this is just like an acknowledgement of the rules, policies, and employee handbook. Because just like the employee handbook, it's used to show they got the handbook. Here they say right there, they got the handbook, they understood the rules, they were given an opportunity to talk to somebody, and so forth. Same thing, and possibly more important, with a remote work agreement. Basically, you go over the highlights of all the things that are, you have a standalone remote work agreement, and you put in there the highlights or subjects of all the remote work policies that you have, and have the employee sign it to agree that they're going to follow those things.
Right. Okay.
And so we're at 9:53. I don't know if there are any questions coming in, but I purposefully left some time for that.
Perfect. Thank you. Yes, please. If any attendee does have a question, please put your question in the Q&A. We'll give it a minute or so. Oh, we have one right away. When an employee is taking care of children while working and are interrupted consistently during meetings, what actions can we take?
Well, that would be an issue of, if it's a non-exempt employee, if it's more than just a minute or two, well, let's address two situations: the time of work and the disruption. If they're spending more than a minute or two, you don't have to pay for that time that they're dealing with their children exclusively. As far as the interruption, you can have a remote work policy that, if you are, if you're pulled away on personal things and it disrupts, operations or what have you, you can be disciplined.
Okay. Then we have another question, and it's saying, can we ask about childcare situation when deciding if an employee can work remotely while interviewing?
I would say too dicey.
Too dicey. I know.
Because there's a category of it maybe doesn't apply, but there's a category of it's not a protected category to be parent. There's marital status, which some plaintiff's attorney may try to spin into that, but even the idea of it doesn't look good.
Okay, so just assuming you hire
so to be clear,
okay.
You don't want to ask them about being hired, but it's a legitimate consideration if it proves to be disruptive or a lot of time away from work.
Okay, so for example, if you interview somebody, you don't ask them the question about childcare, then you make the offer and that topic comes up. And then would you be able to, if it becomes an issue very shortly thereafter, that's a disciplinary issue, correct?
It is, but make sure you have a lot of actual facts and evidence.
Okay. Okay, we have another question. It says, what's allowed to add on an agreement? I think
it's a little general, but let me just say this. You could put in anything in the agreement that relates to or restates or summarizes the remote work policies or the situations in which they received and had opportunities with respect to those policies.
Okay. And then we have, how does COVID ending May 11th change the work from home option?
It doesn't. Well, it's a little general, but the only change is a practical one in that the whole COVID and remote work has caused people to have expectations or have some idea that you can do this or you can't do that. It's not.
Okay.
Because COVID is over.
Right. Just as quickly as it came, it has Um,
Yeah.
Okay, it does not look like we have any, I'll wait another minute to see if we have any more questions. So thank you, Robert, so much for all this information. It's really good, and I'm glad that we were able to have this, because I think it's very, very informative. And for those of us that deal with remote work and our clients, it's been very helpful. So at this time, we're going to go ahead and wrap up. We remind you that we will be sending a copy of today's presentation to everybody who is attending and registered for the webinar. And if you have any questions, please don't hesitate to reach out to our office. We think, I want to thank everybody again for joining. Robert, thank you. Always so informative. And we hope that everybody has a wonderful rest of the afternoon and day. All right. Thanks so much.
Bye, folks.
Bye.